Pleased to gavel in the second hearing of the Subcommittee on Border Management, Federal Workforce, and Regulatory Affairs. And today is a regulatory affairs conversation. This subcommittee has very broad jurisdiction ranging from border security, operations of the federal workforce, the world of regulatory affairs. In our first hearing that we we examined how to secure our borders while facilitating still safe, efficient travel as millions around the world prepare to gather with us to celebrate the 2026 World Cup, America's 250th birthday upcoming next year, and the 2028 Los Angeles Olympics, which are really the 2028 Oklahoma City Olympics, because we also have two events there. Today, we'll turn our focus to another topic in our Regulatory Affairs Authority, Congress's role in the regulatory landscape post-Chevron. During my time in Congress, I've chaired several hearings on regulatory affairs and the need for stronger congressional oversight of the administrative state. However, this hearing is a little different. For 40 years, the Chevron deference has guided the courts to defer to agencies' interpretations of ambiguous statutes, often at the expense of congressional intent. That era is now over. On June 28, 2024, in the Loper-Bright Enterprises versus Raimondo, the Supreme Court overturned Chevron, and in doing so, the court restored a fundamental principle that it's the job of Congress, not unelected bureaucrats, to write the nation's law. It's also the job of the courts to say what the law is, not the agency. More than a year later, courts, scholars, and policymakers continue to unpack the direction which the new regulatory world operates. The purpose of today's hearing is to not just simply reflect on the decision, but to chart a clear path forward on what Congress must do. We will explore how Congress must adapt its legislative function in light of Loper-Bright. Ambiguity is no longer a shield to allow administrative agencies to determine what the law means. We must examine the tools of Congress to rein in the regulatory overreach and provide a clear and stable framework for Americans to live and do business free of the ever-shifting whims of any agency decision in Washington. We'll also discuss the change of the standard of judicial review. After Chevron, how courts will interpret unclear statutory language is still unresolved. What sort of deference, if any, will courts give to agencies? Finally, we'll consider the impact of the recent Corner Post decision issued 3 days after Loper-Bright. In that case, the court held that the statute of limitations for changing agency actions begins when the plaintiff is injured, not when the rule is issued. This shift has opened the door for new regulated parties to challenge longstanding rules, raising questions about the stability of existing agency interpretations held under Chevron. Today's discussion will help us identify practical reforms to ensure that laws passed by Congress are clear, while making sure the administrative state is accountable to the people's elected representatives. I really look forward to hearing from our three distinguished witnesses that are here today, and grateful that you are here. I've had the opportunity to be able to go through your written statements. I appreciate very much, excuse me again, I appreciate very much both your academic work and your research on this, the time and the thought that you put into this, and I appreciate that more than you know as we go into this hearing time. We have three different witnesses before us today, and looking forward to this conversation. Professor Chad Squitieri, professor at Catholic University at America's Columbus School of Law, is assistant professor of law there, where he serves as the director of Separation of Powers Institute and is a managing director of the Center of the Constitution and the Catholic Intellectual Tradition. Prior to joining the faculty of the Catholic University of America, he practiced law in Washington, D.C. He's also served as special assistant to the United States Secretary of Labor, Eugene Scalia, as well as a law clerk as Judge Brooks Smith on the United States Court of Appeal for the Third Circuit. He graduated from Florida State University and the University of Virginia School of Law. I guess OU School of Law wasn't good enough for you, but I'd invite you to be able to come there instead. Professor Susan Dudley from George Washington University. She's the Distinguished Professor of Practice at the Trachtenberg School of Public Policy and Public Administration at George Washington University. She formerly served as the director of GW's Regulatory Studies Center. From April 2007 to January 2009, Professor Dudley served as the administrator of the Office of Information and Regulatory Affairs in the United States. She is one of the leading voices in this area, and we're very grateful for your time to be able to be here. She directed the Regulatory Studies program at Mercatus Center at George Mason University, taught courses at George Mason University School of Law. Additionally, Professor Dudley served as an economist in OIRA, the EPA, Commodities Future Trading Commission. She holds a Master of Science degree from MIT, Bachelor of Science degree from the University of Massachusetts Amherst. Thank you. It's great to see you again. Thanks for your leadership for so many years. Allyson Schwartz, so I get to call you Representative Schwartz, or what's the best title now? Deal. She currently serves as the co-chair of the Bipartisan Policy Center's Health Housing Task Force and served as the Bipartisan Policy Center's working group on Congress, the courts, and administrative law. Before her time at the Bipartisan Policy Center, Representative Schwartz served as a member of the House of Representatives for Pennsylvania's 13th Congressional District from 2005 to 2015 and is a nationally recognized leader in healthcare issues. In Congress, Representative Schwartz was appointed to the House Ways and Means Committee and served as a senior member of the House Budget Committee. Prior to her election in Congress, Representative Schwartz served in the Pennsylvania State Senate from 1991 to 2005 and worked as a healthcare executive. Have you adjusted to being on that side of the table yet? Yeah, I bet it does. I bet it does. We are exceptionally grateful for your time to be able to be here. We do swear in witnesses, and Senator Fetterman will be here. As soon as he gets here, we'll allow him to be able to step in and do his opening statements as well. But if you both, or all three, I should say, would rise. Please raise your right hand. Do you swear the testimony you will give before the subcommittee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Thank you all. You may be seated. We're going to take this in the reverse order that I did the introduction, beginning with Representative Schwartz. Thank you again for being here, and we're ready to receive your testimony. Yeah.
I'm actually very pleased to be here, so I take back my previous comments about how I'm feeling a little strange. But Chairman Langford and to Senator Ertz and to Senator Fetterman, who will be here soon, I understand. Thank you for convening this hearing and for your attention to the Supreme Court's decision on Loper-Bright and its implications for congressional responsibilities. I welcome the opportunity, in particular, to discuss the Bipartisan Policy Center's report, Legislating After Loper. The report provides practical actions to address the expectations set out by the court for legislative process and legislative language. The working group on which I served that prepared the PPC report shared a deep respect for the authority and responsibility granted to Congress by the Constitution. We recognize that Congress must respond to the court's decisions and do so for its own good and to avoid intervention by the courts in the future. We sought bipartisan, achievable remedies. We saw this moment as both a challenge and an opportunity to address needed reforms to improve legislative processes and provide greater clarity and understanding of legislative language. Such reforms will be useful to members, to regulatory agencies, and to the public. As a former member of Congress, I understand the importance of getting that balance right between being too prescriptive or too vague in giving too much leeway or not enough authority to regulatory agencies. Legislators seek to provide specificity where they can while granting flexibility to the agencies to use their expertise to implement the law most effectively. Yet the court was clear. As currently drafted, laws are often not specific enough. Added to this conversation are subsequent court decisions that recognize the necessary role of administrative agencies. The Supreme Court acknowledged that agencies have special expertise on technical subjects and should be allowed to apply that expertise. Historically, Congress has agreed. The remedy for Congress starts with greater clarity in defining the purpose and intent of legislation, and to be more explicit in legislative language and the authority given to regulators. Without such improvements, courts will disrupt Congress's constitutional obligation to write the laws of our land. This is an unacceptable outcome for Congress and for our democracy. Issues of process need to be addressed. Congress increasingly fails to operate according to regular order. Instead, Congress uses continuing resolutions, omnibus bills, and fast tracking of major legislation that are too big and too rushed. It undermines a key tool for communicating congressional purpose and guiding agency actions through hearings, committee debate, and time for public reaction. A robust legislative record guards against agency misinterpreting the law. Further comments include strengthening internal expertise by investing in additional resources for committee staff, providing greater clarity regarding the boundaries of delegation to the agencies by further investing in the Office of Legislative Counsel, support the committee process by ensuring committee review and debate and access to external experts, and improving Congress how Congress works with regulatory agencies by recognizing the interaction necessary during legislative and regulatory processes. This includes adequate funding for the agency's periodic review of implementation and timely reauthorization. There is work ahead for the House and the Senate to ensure greater clarity of regulators and the courts. Using these recommendations will enhance the regulatory process and ensure implementation of the purpose and intent of Congress. It will also enhance public engagement and understanding of the impact of legislation. Most importantly, it will ensure the role of Congress as a constitutionally granted lawmaking branch of government. I request that the full PPC report be entered into the record, and I hope that you will consider BPC as a resource as you proceed. And thank you for your consideration.
Thank you. Thank you. And without objection, the full document will be entered in the record. Senator Fetterman, I recognize you for your opening statement. Thanks for being here.
Oh, thank you, Mr. Chairman. Thank you, Mr. Chairman, and thank you to all of our witnesses joining today. This sounds kind of a more obscure kind of a topic, but this is one that things that will have the effect of every single one of us. Every time we pass a law, federal agencies have to implement it. And usually that includes issuing regulations and creating a process that makes sure that those laws are followed. Sometimes the agency gets a little too excited or goes a little too far, and sometimes they don't go far enough. And that's where the courts are added to this conversations. Last year's decision, Looper-Bright, changed the way the courts have been treating federal agency decision-making for the last 40 years. That is a huge change, and we're going to need to figure out how we all have to adjust. When we got too tied up in DC speak about this stuff, people tune out. But how we have to respond, this change could be the difference between whether the water that we drink is clean or the cars that we drive are safe and the air we breathe won't make us sick. We need to remember this is really about making sure that we are explaining to these folks trying to make it work on time, provide for their families, and save for retirement. The only answer we really need to get to here is how does this change things, and what do we need now change as a result? I look forward to hearing to our witnesses.
Thanks, Senator Fetterman, very much. Susan Dudley, you're recognized for your opening statement. Thank you, Professor.
Chairman Langford, Ranking Member Fetterman, Senator Hassan, thank you. Yes, thank you for inviting me to share my thoughts on the implications of the recent Supreme Court decision in Loper-Bright v. Raimondo. I'll provide a little background and then offer 4 recommendations for Congress. When developing and justifying new regulations, agencies must first interpret their statutory authority, second, examine and filter factual and technical information to identify regulatory approaches, third, make policy judgments regarding which approach will best meet their statutory obligations and serve the public interest. For the last 4 decades, agencies have enjoyed deference in all these areas on the grounds that their expertise and their accountability through the president made them well suited to act in the public interest. The Loper decision last year overturned deference to agencies' interpretations of what their statutes authorize, holding that courts should decide what the law is. However, nothing in that decision is likely to alter the deference agencies receive in the other 2 areas, fact-finding and policy judgment. Judges in the executive branch are already grappling with how to apply the new doctrine. As for Congress, legislators will no longer be able to pass ambiguous laws with the expectation that agencies' interpretations will get deference. But I don't think that means statutory language will have to be detailed and precise. Laws that delegate broad authority could defer to agencies' fact-finding and policy expertise as long as they do so unambiguously. To write less ambiguous laws, I suggest that Congress more clearly distinguish between questions of fact, such as does a chemical show adverse effects in laboratory experiments, questions of policy, what restrictions should be placed on that chemical, and questions in between, such as how do you extrapolate between findings of from high-dose animal experiments to low-dose human exposure. First, legislation should recognize that while scientific facts are a necessary element of good policy, they are almost never sufficient. Many regulatory decisions involve what noted physicist Alvin Weinberg called trans science, relating to questions that science can inform but not answer. Statutes can allow agencies to fill up the details, but require them to be transparent about the studies, assumptions, models, and other trans science factors they rely on. Second, legislation should provide clear guidance on how to weigh competing considerations. For example, this committee has introduced bipartisan bills in the past to codify long-standing executive requirements for regulatory impact analysis, including benefit cost analysis, to ensure that agencies consider trade-offs transparently and systematically. Statutes like the Safe Drinking Water Act that explicitly authorize Congress to consider balancing factors have been more effective and less acrimonious than directives like sections of the Clean Air Act that seem to preclude those considerations. Third, to better inform reauthorizations and promote a culture of learning, Congress could require agencies to evaluate their regulations periodically to determine how effective they are at achieving legislative goals and to identify needed revisions both to the regulations and the underlying statutory authority. So I'm supportive of legislation this committee has introduced in the past, requiring that when first developing regulations, agencies establish clear performance metrics, commit to a plan for retrospective review, and use the results of that review to reassess the regulation. Fourth, to support these efforts, Congress itself needs more resources. So I was also on the Bipartisan Policy Committee that Representative Schwartz mentioned, and I'll agree with that recommendation fully. I think a dedicated Congressional Regulatory Office, a counterpart to OIRA like the CBO is to the budget side of OMB, could help lawmakers draft clearer statutes and better understand the legal and policy implications of proposed legislation. So in conclusion, the new landscape places greater responsibilities on Congress to write less ambiguous statutes that more clearly recognize the different considerations, legal, fact-finding, and policy that go into writing effective rules. By requiring agencies to lay out their judgments and assumptions transparently, explicitly authorizing them to weigh important trade-offs, and learning from ex post evaluation, Congress can ensure regulatory decisions are more transparent, accountable, and grounded in both sound science and legitimate policy judgment. My written testimony has more detail on these points, maybe too much more detail, and I look forward to answering your questions.
Grateful to have the detail on that. Professor Squitieri.
Chairman Langford, Ranking Member Fetterman, and distinguished members of the subcommittee, thank you for inviting me here to discuss how Congress can respond to the Supreme Court's opinion in Loper-Bright. My name is Chaz Squitieri. I'm Assistant Professor of Law at the Catholic University of America, where I focus on administrative law and the constitutional separation of powers. In connection with my work as a professor, I serve as the director of the Separation of Powers Institute and as a managing director for the Center for the Constitution and the Catholic Intellectual Tradition. Loper-Bright brought about a welcome change to administrative law. Under the old Chevron regime, courts would often adopt a less than best reading of a statute because that reading was offered by an administrative agency. This required courts to favor one class of litigants, federal agencies, over other types of litigants, such as the private citizens who alleged that their government had acted unlawfully. This state of affairs was inappropriate because federal judges should not give undue preference to any litigant that comes before them, including federal agencies. But while Loper-Bright played an important role in beginning to level the field on which private citizens and federal agencies litigate, I wish today to step back and take a wider look at things and suggest that Loper-Bright was in some sense small potatoes. And my hope is that by situating Loper-Bright within the broader framework of administrative law, this subcommittee can better use Loper-Bright's momentum to make progress on a variety of topics that Loper-Bright relates to, but did not formally address. So to speak briefly and in general terms, a good bit of agency decision-making can be categorized into three buckets: findings of fact, policy decisions, and conclusions of law, and courts review those different decisions through different standards of review. Loper-Bright only addressed how courts review agency decisions that fall within the third bucket, conclusions of law. More specifically, Loper-Bright only addressed one type of a conclusion of law, namely those relating to statutory interpretation. Loper-Bright did not purport to change how courts review agency conclusions of law relating to interpretations of regulations, nor did the decision purport to change anything about how courts review questions of fact or policy. To bring this point home, the Supreme Court recently ruled that in a particular environmental context, courts should afford substantial deference to fact-dependent, context-specific, and policy-laden choices made by agencies. So I highlight what Loper-Bright did not do because Congress should consider picking up where Loper-Bright left off and consider three changes. First, Congress should make clear that courts must not defer to agency conclusions of law when interpreting regulatory terms, similar to how Loper-Bright already makes clear that courts must not defer to agency conclusions of law when interpreting statutory terms. Currently, courts must give Kaiser deference to agency conclusions of law when interpreting regulations. The name Kaiser comes from a 2019 Supreme Court decision in which the court was asked to formally overrule that type of deference. Although several justices in Kaiser were prepared to overrule it, a slim majority decided to keep that form of deference due to stare decisis. The legal rationale, however, for Kaiser has been called into question by Loper-Bright, and Congress can therefore alleviate some uncertainty by stating that Kaiser deference, like Chevron deference, is no longer permitted. Congress could do this in a big way by amending the APA. Alternatively, Congress could do away with Kaiser deference on a more tailored basis by amending specific statutes relating to specific agencies. Second, Congress should both be conscious of when it grants policy discretion and consider cabining that discretion when appropriate. Courts typically review agency policy decisions under the arbitrary and capricious standard, and under that standard, a court asks not whether it agrees with the agency decision, but rather only whether the agency action was reasonable and reasonably explained. This is a generous standard of review from an agency's perspective, which makes sense as courts should not be in the policy-making business. But Congress most certainly should be in the policymaking business, and thus Congress should be conscious of when it is empowering agencies to exercise policy discretion on Congress's behalf, and Congress should consider cabining that discretion when appropriate. So as to when legislation grants policy discretion, courts might interpret legislation as granting such discretion when legislation uses terms like appropriate or reasonable, and when legislation expressly delegates to an agency the authority to give meaning to a particular statutory term. As it had to cabin such discretion, Congress could make clear that agencies must consider certain factors when making policy judgments. For example, Congress might require agencies to consider whether regulatory policy helps or hurts American industry. Statutorily required considerations can be thought of as speed bumps or nudges. They won't require agencies to develop policy in one direction, but they can cause an agency to slow down, show their math, and exercise policy discretion in a way Congress prefers. Third and finally, Congress should make more policy decisions itself rather than delegate substantial discretion to agencies. In a recent non-delegation decision, the Supreme Court more or less passed on an opportunity to give Congress some encouragement on this front, but Congress need not wait on the federal judiciary to begin reining in delegations. Congress can do so now and on its own initiative. So in conclusion, thank you for inviting me here today to discuss how Congress can respond to the important but nonetheless limited change to administrative law brought about by Loper-Bright.
Thank you. Thank you to all three of you. I'm going to defer my questions to the very end. We have some ongoing votes that are happening now, and I'm going to recognize Senator Fetterman and Senator Hassan immediately after that as well. So Senator Fetterman, you're recognized for questions.
Thank you, Chair. Yes. Hi. Congresswoman, I haven't seen you in a while. Yeah, well, I have a question, and there's a right answer. Steelers or Eagles? Have we ever?
That's not a question. It's the Eagles for me. I know this is a disagreement between the West and the East.
But no, we can still get along then. But now, shifting. Okay. The pressure is on us now. We have to be more direct in the bills, and we must be more active in legislating on difficult topics. You were on the working group from the Bipartisan Policy Center report that you talked about in your opening statement, and you were up to a decade actually doing that work. From your experience in the House, And in your work at the BPC, what is the number one issue that we need to address in light of the change in deference?
Thank you, Senator, and it's good to see you. I would say, if I have to pick one, it really is about making sure that legislation articulates very clearly what the purpose and intent of that legislation is. I think that provides a direction to the agencies, and I think you can be more explicit about goals and timing, and I think that's what's most important. I do think that, so this maybe adds a second, but it's connected, is to be clearer in the authority you give to the agencies. The agencies do have expertise. As members of Congress, we rely on that, and the agencies to do that. But Congress could be more explicit in the how much delegation they want to give and what the parameters of that delegation is. So I do think that both of those things together, it makes it much clearer what Congress wants to get done and what the goals are. So if I had to pick one, I would say that those are the ones that really matter and good start.
Would you like to?
Senator Hassan.
Well, thank you very much, Chair Langford and Ranking Member Fetterman, and good afternoon to our witnesses. It's good to see all of you. And Ms. Dudley, I think I hear that we share a high school in common. So
We do indeed. I was a few years ahead of you, but yes.
well, it is nice to see another Lincoln Sudbury graduate. So let me start with a question to you, Ms. Dudley. And it's really a follow-up on your opening testimony. Congress needs to work in a bipartisan way to ensure standards and rules are effective and allow government to work better and faster for taxpayers. In addition, Congress needs to make its intent clear when passing legislation so that federal agencies can effectively deliver government services. So you talked some about this, but you also referenced a little bit more detail. So what are the most effective steps Congress can take to ensure that the intent of Congress is clear and at the same time to really improve government efficiency as we go about this work?
So one of the things that I stress in my written testimony is that there are different factors that go into good policy, and that we have a tendency to say agencies should base a decision on the science or on the facts. But the facts alone often don't translate nicely into a policy decision, just isn't that neat. So understanding the different factors and being explicit about what the agency should consider, not necessarily how it should consider it, but how to think about the different trade-offs involved.
Thank you. Congresswoman Schwartz, it's good to see you. You've highlighted that the Loper-Bright decision will strain Congress's capacity to draft laws with the level of specificity now required. How do we realistically build the capacity within Congress to draft laws with the kind of precision now expected by the courts? Yeah.
I would know that. We do suggest in the report that first you could really continue this process. So thank you for having this hearing initially, but to create a bipartisan process to review what could be done and what you're willing to do. We've seen the House already hold a select committee on modernization of their rules and procedures. I think that goes a long way. You could do something similar, but it's important to make sure that you have some bipartisan efforts going forward. So we do suggest investing in staff and the expertise in staff so that we don't, well, there's a lot of relying on the expertise in the agencies, but having more expertise. And so we suggest even a fund to be able to hire experts when you need to. We know some laws are very explicit and some are more general. So we need to figure out how you can be more explicit about the direction. And that could be by having more expertise here in the Senate and in the House, and be able to work together on that. I think that makes a big difference.
Well, thank you for that. And kind of a follow-up, I'm concerned that in the wake of Loper-Bright, we may see a retreat from evidence-based policymaking just at a time when I think we really need to be evidence-based. And I'm concerned we'll see it particularly in areas where Congress has historically relied on agency experts to apply the best available science and data. We know that some degree of agency flexibility is also essential for implementing laws effectively in complex and evolving areas. I mean, you can't always, a lot of these facts are not static, right? As we're addressing some of the most significant challenges we have. So in your view, how can Congress strike the right balance, drafting laws with enough specificity to withstand judicial scrutiny while still allowing agencies to apply their expertise and respond to new evidence over time?
Well, you have it exactly right. That getting that balance right is not something we always do. And I understand that sometimes we don't get specific because it makes it harder to pass legislation. And I've been in both situations where we got very explicit, as in the ACA, and in others where we've seen it more general. So I guess I would say it's always going to be a balance. But I think the more we can understand what those choices are and to guide that choice, but not necessarily all the details of that choice. Because and I think we need more reporting back from the agencies if they're struggling here. This conversation can happen during the regulatory process and more accountability to check in and see how it's working a year or two later. We've done that. We modify laws all the time because our experience has told us we need to. But they have to come back to you have to come back to you. They have to come back to the Senate and the House. They can't just decide on their own. And honestly, we're seeing a whole lot of expression and by the executive branch of, I think, getting way over their skis on this, and to exert the power of the Senate and the House to make these laws. If they want to see it done really differently, they need to come back and say, you got to change the law to let us do it. I think that is a way to demand that kind of, and exert the power of the House and the Senate to actually make the laws and to help in the interpretation of those laws as well.
So one of the things that I'm hearing you say, among others, or a couple of the things, is that we really need to be articulating goals and metrics within legislation where that applies.
That's right. And I think there's nothing wrong with actually asking for data. And I think Susan's going to talk about this maybe, but evidence, you can create evidence any way you want.
Right.
So not that I don't believe there isn't fact, I do. But we're in an era right now where there's so much misinformation and misunderstanding about facts that we need to be clear about what you intend, sorry, it's not we anymore, but you intend, and to have that kind of back and forth and understanding.
Thank you. Ms. Dudley, you wanted to...
Just a quick reinforcement of what you both just said. We have a lot of challenges that are evolving, and we have to design both laws and the regulations with learning in mind so that we can learn, test, evaluate, and then revise and revisit.
Right.
So I
appreciate you both. Thank you very much.
Senator Fetterman, do you have additional questions you want to be able to ask right now?
It's more of a quick one.
Yeah, that'd be great. Go ahead. And then what I think I'm going to do is then after Senator Fetterman's question, take a quick recess. We've all got to be able to run vote, and then I'll be back, and I'll have about, 900 questions for you when I get back, and I'll defer mine to the end, but we'll have quite a few more than at the end. So, Senator Fetterman.
Yeah, my question is actually for all of you. Congress doesn't write perfect bills. We avoid detail to keep majorities. We need to pass bills. Sometimes we think we're being clear, and we're not. We are also can't see the future, and our decisions likely are going to have some unintended consequences. What are the courts and agencies going to do now that they have to determine best reading, and now what the Congress needs to do in order to be ready to react in those situations?
So, Senator, I can start answering that question. So, at least from the judicial perspective, courts have been instructed from the Supreme Court now to use really every tool in the interpretive toolbox to come down to give a statute its best reading. And this is familiar to the judicial task in non-administrative law areas of the law as well, like, like a criminal statute, for example. There is no agency for the courts to kind of throw up its hands and defer to what the agency view is. So the court has to come to a meaning of the law there. And post-Loper-Bright, courts are under instruction to do the same thing in the administrative law context. So using statutory canons, precedent, dictionaries, what have you, coming to what the court's own independent judgment is about what the best meaning of the law.
Does any of you have a response?
I think agencies, too, obviously will have to do that. And research by Chris Walker at Michigan Law found that they already are. They're relying less on Chevron, the assumption that they'll get Chevron deference, and working harder to interpret the best interpretation. So maybe getting back to what Representative Schwartz was saying, the iteration and the back and forth, the communication between the executive and the legislative branch could help there.
I would just ask that, I would just again reiterate the fact that it's Congress that actually makes these decisions ultimately. So coming back to Congress if they need to, is one possibility. But again, making sure that you have the expertise and they have the expertise. It does not help to have hollowed out so much of the expertise in these agencies. How can you rely on them if there's no one there to pick up the phone, so to speak, which is happening? You know that, you see it. We expect more cuts to happen. And I think that's a real problem to invest. We invest a lot of confidence in the agencies, and we always had. And some are civil servants who serve Republicans and Democratic administrations. They know this field. But again, if they have questions, or you do, in terms of the regulation, there are comment periods. I think we don't actually use that comment period very well. We actually leave that to the outside interest groups and representatives and individuals to write in, but doesn't mean that Congress can't also say, we didn't quite mean this, I suppose, and really try and articulate that better. So I think there are opportunities that exist. But again, making sure that you have the expertise to be able to respond, and making sure that there are experts in the agencies you can rely on, and because you want to do their jobs completely. The other, as I would say, is again, don't use reauthorization the way we could. We sometimes wait on reauthorization for years, or we just continue to say, okay, we don't have time, just let it go. I have one big one coming up. MACRA expires at the end of the year. Is there a real discussion we know should be going on about changes that could be made to enhance that legislation? There's a lot of bipartisan interest in it working, but it really, to just let it go another year or 2 or 3 could actually undermine a really important effort that's been passed by Congress. But it needs time and effort to actually get into what should change and what could improve that law. So I would use the reauthorization process and also ask for, we talked about this, a possible review of how a law has been implemented. What's the data? What's the evidence? What is it doing what we want it to? And you can do that. You can find out, are people healthier as a result of what we did, or are they worse off? Are they spending more money as consumers, or they're not? Is in fact the air cleaner because we've getting rid of our efforts to do clean energy? Are we happy with what's happening? Is that working for us or for you and for the American people? That's something you could call on in law to say, I want to report back in a year or 2, even before reauthorization, to be, how is this working, and how could we improve it if we need to?
Yeah. I appreciate that very much, Senator Fetterman. Thank you for that as well. I am the cheerleader for retrospective review, and to say, how do we go back and to be able to look and see if this actually worked the way that we hoped that it would work. We never know until we actually test it, but in this town, no one wants to ask questions later, just keep moving forward. It is helpful to be able to go back and look. I'm going to ask, because of the votes that are happening on the floor right now, the subcommittee would stand in a brief recess subject to the call of the chair. I should be back in 10 minutes or less, and that gives everybody a rare moment to be able to stand up and stretch, and then we'll come back for my last 900 questions. So thank you. We stand in recess till the call of the chair.
He's not joking.
Committee will come back to order. Thank you all for allowing me to be able to pause, run, vote, and then to be able to come back. Again, I appreciate the work on this. Let me start with some general comments. A couple things have been stated about things that Congress shouldn't say. The word appropriate has already come up once on it. I'll add to the word reasonable into it as well. But my question for you is, let's go ahead and write a vocabulary right now. What are the words that are most likely words or phrases that Congress is going to have to go back and look at again and say, we need to be careful when we actually write these words, because it becomes so broad, but they're common. So I've raised 2: appropriate, reasonable. What else would you add to our vocabulary list? Any of the 3 of you, jump ball.
I might say science-based, because it's too vague. Even something like protective of public health. We all want things to be protective of public health, but it's not as so recognizing that there are other factors beyond public health, or that factor into that.
Right. It becomes a pretty broad statement to say this is for the public health.
Yeah.
Okay. What else?
Senator, another category is when a statute gives express defining authority to an agency. So it's common, for example, a statute might say, Secretary so-and-so must do X as defined by him. And that is perhaps more obvious that it's giving discretion to the agency. But it's kind of unique because it's giving legal rulemaking authority to the secretary in that context, not just like policy or fact basis, giving like the authorities that you can essentially kind of make a small law. And Loper-Bright has a line in a very important part of the opinion saying that's still permitted. Some of the justices, I think, were prepared to say that wouldn't be permitted as a constitutional matter,
right.
But would still be permitted. So it's just another category to be aware of.
Mr. Squitieri, you had mentioned the non-delegation doctrine and that the court has not taken that up to be able to address that for a very long time on it. That's one of those issues when it's basically giving authority to an agency to go create things that, as you stated, as defined by whoever this may be, that's going to make the decision. They are suddenly the lawmaker at that point. At what point would you recommend that Congress engage in saying, well, why are we delegating power away? Or at what point does the court step in and say, that's not a power you can give away, that's Article I authority, you can't give that to Article II?
Right, so I'll say that's spot on, and Loper-Bright, in that part of the opinion, the court says basically that the court's job there is to just police the outer limits of that kind of delegation, and what the court's referring to is like the non-delegation doctrine expressly. The court had an opportunity this last term to kind of reinvigorate the non-delegation doctrine, and they more or less passed on it. I wish they hadn't, but I'm not on the Supreme Court. But that doesn't mean that Congress can't reinvigorate the non-delegation doctrine itself. It just means that the court is not going to hold Congress's feet to the fire.
Okay, that's helpful. Representative Schwartz, you have more vocabulary you want to add to our list?
Well, I was going to answer it this way. I think the thing that has to be worked out is if the court really thinks it's not specific enough or the agency's overstepped, the issue for me is who makes the decision then? Do they actually refer it back to Congress, or are they referring it back into, are they going to make a decision? And clearly they should either referring it back to an agency or they should refer it back to Congress. The concern I have is that the court oversteps its bound and starts to make the decision for us. And I think that's something Congress has to be deeply concerned about, because clearly it's Congress's role to make the law. Theirs is to make sure it's constitutional, but that's not to make policy. Right. And so I think that's one of the ways to think about delegation and how much authority you can give them. If you're making clear about the policy, but the details of that policy, they can look at different choices. You know, I think that might help to be a little clearer about it. How you actually do that depends on, you know, what the issues are, and to be as specific as you can in, again, the authority you're giving and the direction you're giving to the agencies. But then just make sure at the end of the day, it's not the court who's taking the job of Congress.
There's been some conversation as well about when a piece of legislation statute is silent on an issue, who gets to be able to speak into it. And I have long been a proponent that nothing doesn't mean something, nothing means nothing. And there has been this argument that if it's silent, that the agency may need to get to fill that in. And the court seems to be pushing back and saying, no, silence means silence, that you don't have the authority to be able to do that.
I did one other thing I think that's interesting, and maybe it's true, but I also think that that's where the expertise within Congress and this, the House and the Senate comes into bear, is that I know there was something that got dropped out of the reconciliation package that gave the secretary the right to, said to deal with something that had to do with taxation. And some observers did call them on and say, whoa, wait a minute, you can't just say I think it was an international work, but it got pulled and dropped because someone said, that's ridiculous. You can't completely turn over this whole package of taxation to the secretary of Commerce. So I think that's another way for Congress to be able to police itself in a careful review by Ledge Council to say, where have we been too vague, and where actually have we given enough direction to make it clear enough for the agencies to make the choice in the directions we want.
Right. Professor Dudley, both of you have actually mentioned an OIRA-like entity within Congress to be able to look at legislation as it's going to the floor, to be able to examine it and to say, is this language tight? Representative Schwartz, you know full well, Congress doesn't have a body that's like that to be able to check it. We're self-checking it among our staff. There is no process to be able to review, as OIRA has the ability to be able to review regulations as they're going out the door. How do you see that would function? And it's an interesting proposal to be able to make and to be able to offer.
Yeah, and this was also a recommendation that was raised at a National Academy of Sciences workshop that I was involved in, looking at the effect of Loper-Bright on agencies, especially health and safety agencies. And one of the recommendations that came out of that was an OIRA-like office, a Congressional Regulatory Office. So I think it could do both things. I don't think it wouldn't have to be huge. So OIRA is about 50 people. I don't think it would have to be that big because it wouldn't be doing the same number of transactions. But still people with that expertise like the CBO that provides you that counterpart to OMB. So it would be able to do both the support that the BPC report talks about that Congress needs for drafting legislation, reauthorizing, but also help you review agencies' regulations under the Congressional Review Act, or also their retrospective evaluations to see what the impacts of the regulations are. Also, can I say that I really liked your last question, and I would love a chance to think more about your vocabulary and come back to you more on that.
I would be glad to be able to have any insight you have on that. You have a busy schedule as well, and so if you have any insight on it, it's one of the things that my team and I, we've talked about to say, how do we help, absent an OIRA-like entity, to be able to help our counterparts to say, what are the words we should watch for? To know that this gives away a tremendous amount of authority to someone else that's not Article 1, to be able to make decisions that look a lot like Article 1 that the court is now saying, hey, that's not really something that is clear. That creates ambiguity, basically. We shouldn't be writing something now, especially now, that we know creates ambiguity. When we know already the court is saying if it's ambiguous, it's got to get back to Congress. What I've often said is if you take a group of letters from a Scrabble game and just throw them on the table, you shouldn't be able to make of it whatever you want as an agency. You should say that says nothing, or there's no way to tell what that says. So Congress has to go back and do its job to actually say what they mean so that the agency are able to carry out the law in the statute. Go ahead, Professor.
Senator, if I could add to that, I would say even when Congress does use words like appropriate or reasonable, that's not something that Congress should totally avoid. It should just be very conscious of using it. And when Congress does use those terms, I would recommend using what I kind of refer to as like speed bumps, saying the agency, you must do an appropriate measure of blah, blah, blah. And when you do that, consider the effect on American industry, consider the effect on American worker, consider the effect on this endangered species, whatever the policy is. And that will cause Congress, or cause the agency to slow down and kind of show its math and exercise policy in the way that maybe Congress would have if Congress was there overlooking the agency's shoulder. So it's more, Congress, of course, can't know what's 20 years in the future, but they might know we're always going to care about the American worker. So let's make sure that the agency does an analysis of that going forward. So those might be a way to, even when you are using a word like reasonable, to kind of cabin the discretion.
Okay, that's fair.
Do you mind if I jump in on that
Please.
too? Courts are increasingly interpreting language like that to require trade-offs of benefits and costs. Cass Sunstein has referred to it as the cost-benefit state, and if that's the case, then I think that's right. Those are the kinds of things, and Congress could, and again, this is legislation you've introduced, bipartisan bills, that does require agencies to systematically lay out the expected impacts, the benefits, the costs, the distributional impacts, the unintended consequences. So if that could be incorporated, if it could be interpreted that that's what reasonable and appropriate means, Justice Scalia's interpretation, it can't be reasonable not to consider the costs, I think that could make that vocabulary allowed if Congress reinforces the court's interpretation that requires a balancing.
Okay, that's helpful. Professor Dudley, you had mentioned about doing Congress actually engaging in the comment period more, and that when that notice and comment comes out, that we actually comment on it as members of Congress as well, and to say this was the intent of this. I was the author, or I was a part of that committee. This was the conversation. Make sure it follows through this. That's not something that's common at this point, to be able to engage with an agency at that level in a more formal process. I think that's a very interesting idea. That is something that we could actually put on the record. That is something courts have looked at occasionally, to go back and look at the debate on the floor or statements that were put in for the record, to be able to say when they're interpreting a law, sometimes they will go back to that. But it's not often that we do that with an agency for that. So I find
that was actually Congressman Schwartz's excellent point, I think.
Yeah. That's right. It was. But I was also going to say that I think I guess one of the things I think all this has sort of all these are good ideas. I do think we want to make sure that it isn't so cumbersome for Congress that you actually can't pass any laws. Right. So I think that you need to give yourself some leeway in this, that the court has to be more prescriptive, more directed, clearer in intent, clearer in language. I think all of that's a good idea. But then you also don't want to tie your hands so much that you can't actually say, look, this is difficult for us to figure out. We want to do it as you've been through this a little bit in your own negotiations, and then you get stopped over some details that actually maybe you didn't have to give that many details, but and the other is that things change over time. So you do want to be able to give the agencies some leeway to because by the time they do the regulations, and by the time it's implemented, you're talking about a year later, typically. So who knows what happens with artificial intelligence, and who knows what's going to happen in the world, or whether there are other crises that intervene. So you want some ability to have some leeway for both your own legislating as well as for the agencies.
If Congress was reauthorizing agencies, this would be very different on a regular time period. But currently we're
not so good at what you're supposed to do now, so right. Maybe it would be useful to actually just keep that in mind as you go forward.
That's the challenge that we have, is if we knew 3 years from now we were going to reauthorize this, then we would have that moment to be able to come back and look at it again, but currently that's not happening.
That would be a simpler way to go forward, is to just say we're going to do it, and here's how we're going to do it, and a commitment to do that as close as you can to what else is going on and getting in the way of that.
So there has been some conversation with the courts, and there's still some ambiguity in this as far as going back and reviewing regulations, and what the courts are going to review this and send it back in, whether it's a de novo review, whether this is going to be a Skidmore review that's looking more like the agencies, give me your best counsel, what are you going to do with this? Do you all have thoughts or recommendations on how that should be handled or could be handled better?
So as a formal matter now, and a recent opinion this last term, the court referred to the review as de novo review. That was a debate before that case came down. The court kind of just passionately said de novo review, like see Loper Bright. But at the same time, Loper Bright itself kind of goes out of its way to permit Skidmore respect. I'm not really sure we can call it deference now, but some sort of Skidmore respect. So I think courts will be allowed to continue to use Skidmore as long as they don't cross that line of giving the interpretive authority to the agency. And kind of a hypothetical that I might use to think about it is, for example, like a senator speaking to a staff member. A senator might think, okay, a particular staff member, I know they have an expertise on this topic. They wrote a very persuasive memo. It looks like there's a lot of good citations and authority here. But at the end of the day, like, as the senator, you are not giving the decision-making authority to the staff member, but you are giving an appropriate level of respect depending on the circumstances. So I think the situation is similar between a court and an agency. A court might say, look, I'm going to be the one that interprets the law, but you do have expertise in this. You are statutorily required to do X, Y, Z. And so when you kind of walk into the courtroom, I am inclined to listen to you. Doesn't mean I'm deferring to you. That's not allowed after Loper Bright, but you are kind of inclined to give respect.
Okay, fair enough. So there's an interesting question out there as well that's a post-Loper Bright conversation of all of the decisions that were made based on Chevron. The court said we're grandfathering all of them in, all of them stay. Now the question that hangs out there is, fast forward 5 years, 6 years from now, situations change, an administration comes and repromulgates that rule. goes to the Administrative Procedures Act, handles step by step to be able to repromulgate that particular rule. Should I make the assumption it could not go back to what it was before because the previous version of it was based on Chevron decision? That's not allowed anymore to go back. It sits with a Chevron decision, but if it changes, it can't go back to that. I don't think I'm overstretching this, but I'm trying to be able to kind of stretch the boundaries of our thinking on this to try to figure out how those regulations will be handled in the future. Now, that may be up to a court to be able to make a decision, but I'm literally throwing a hypothetical. But there are decisions that were made even in 2021 on issues that were based on Chevron. They sit there done. They're going to be unchanged, I assume, unless they're repromulgated, but they could never return back to the previous. Does that make sense?
It does, Senator, because you're touching on a part of Loper Bright that is not, as a doctrinal matter, very persuasive, I guess. The court, I think, in that part of the opinion gave a very practical answer and essentially said, we are inclined to let sleeping dogs lie. Don't go back and upset a bunch of regulations. As a pure doctrinal matter, smart lawyers will be able to find ways to challenge those old cases that relied on Chevron, because you could still respect an opinion that relied on Chevron that just said the agency gave a reasonable answer, and then you come and say, okay, Your Honor, you can still respect that precedent saying your last ruling was reasonable, but here's a more reasonable, aka the best one. And so you can overrule that regulation. So as a doctrinal matter, I think those old regulations can certainly still be challenged. If it relied on Chevron in the past, that's a good place to look to challenge old regulations. But the court kind of signaled in more practical terms, look, we're probably not going to look too favorably on this.
Undoing it, right.
Exactly.
Yeah. Any other thoughts on that? I know it's a purely hypothetical situation. We've not faced that before, but just in our consideration of the what ifs of this, it is one of the things that kind of hangs out there on that. As I try to be able to walk through this, some of your testimony mentioned adding legislative counsel. That is I'm trying to figure out if whoever made that recommendation, if you're recommending that similar to this OIRA type format of a separate entity, or if it's more of a recommendation that each office add somebody in, that they're just checking this as it comes through.
That is in the Bipartisan Policy Center paper. So there's more detail about all this and why we think so. But there was suggestion, actually, maybe it's that legislative counsel helps write the law, right? You come up with an idea, and then you go to Leg Counsel, and they draft it, do some drafting, and then you tweak it. At least that's how it works in the House. Maybe you don't have such a thing in the Senate, but it is. The opportunity then is, did that really say what you wanted it to say? There's there's back and forth on it, but the recommendation was to actually enhance that body, not to create a new one necessarily, to just make sure they have the expertise given this decision. And again, I think has been said by others, is that we don't have to go so overboard on this. I think that's the thing. You want to be respectful, of course, because this is now what the Supreme Court decided, but I also think you need to respect the prerogative of Congress to actually say what it wants to say and be able to write legislation it wants to write. So again, we think that Leg House Counsel adding to their expertise could be helpful in that regard. They're used to advising members about how to write legislation, and that is a way to go to enhance the expertise and capacity of that council, because they get pretty backed up, and the House Appropriations Committee has already added dollars to invest more in Leg Counsel. I don't know if that was a reason for it, but is this decision, but it certainly could help in this regard.
Right. So we're back to giving the Leg Counsel or having Leg Counsel advise both directions, the vocabulary. Here's what we're going to use, here's what we're not going to use, here's how to provide clarity, but right. To also have somebody that's there, that they're doing a final review to be able to determine, are we making this too ambiguous? And
again, they're offering counsel, but right. We actually also had some discussion when we were working on this working group about should we come up with some different language, and we struggled with it as well as to what is better language. Obviously, we know that reasonable or appropriate leaves a lot to interpretation, but that doesn't mean you can't still say that if there are parameters around that as to what you expect them to be doing, but I think we've all talked about the idea that they can be using more data and more analysis, and when they do it, I mean, we try to, on some level, as members of Congress, too, to really find out what the economic impact is, and what the cost is, what the impact is going to be on our constituents. That becomes part of the conversation that happens in crafting the laws. So the question is, are we doing a good enough job of that to actually be able to be directive in the authority granted to the agencies to implement, to write the law, and to oversee the implementation of that law? That's ultimately up to the Congress to decide.
It is. Several of you mentioned that you've noticed that agencies are slowing down in the process and thinking this through in a different way. I'd be interested to know if you've seen a specific example of where you perceive agencies at least are paying more attention to this, to say we've got to stick closer to the statutory language. We've got to be able to try to determine intent more rather than try to find the if I can use the major question statement, I've defined the elephant in the mouse hole type effect here to try to draw a little closer. And if anyone has seen a practical example of that at this point or maybe heard of one.
I haven't myself, but that Walker article that I mentioned, he did survey agencies a few years ago and found that they said they saw the writing on the wall and were already trying to justify their interpretations as being the best rather than assuming they would get deference.
Okay, any comment on that? I would tell you from a congressional side of things, I have for years noted that members of Congress will allow the agency to be able to do hard things if it looks hard. And to say, this looks controversial, this is going to cause a lot of issues, we'll go figure out if the administration can figure out a way to do this. And administrations over the last 20 plus years have said, yeah, we'll figure out a way to do it. It needs to be done. So we'll find some ambiguous part of the law. We'll find some area where there's silence. We'll find some way to be able to do it because Congress doesn't want to make the hard call to be able to do it. The major questions doctrine and this decision on Loper-Bright seem to be the Supreme Court saying to Congress, suck it up and do your job. You were sent there to do hard things. Go do hard things. Don't ask someone else to go do the hard thing that's not actually in statute. So for me, this is a pretty clear clarion call to Congress to go back, do more work, pass more legislation. We've lost our muscle memory of passing legislation. We've increased our muscle memory of passing the buck. And we've got to be able to figure out how to be able to take that back at this point. So I really don't blame the executive branch for trying to be able to stretch this. I really do blame my own peers and myself for not finding enough ways to be able to lock it down and to say, no, we have to keep negotiating until we solve this. That's why we're here, is to make sure everyone's heard, everything is negotiated out, everyone had their voice, and we make a decision rather than this is hard, somebody else do it. So we'll figure that out. By the way, I'm not interested in commentary on that because you know I'm right, but you don't have to say it. So that's my biggest challenge on this. I do want to wrap this up and respect everyone's time, but I want to open this up for any final comment that you may have. Professor Squitieri.
I'll just, I like the way you just made that last point, Senator, and it reminds me, there's a law professor, Gary Lawson, he kind of has famously said that Congress likes saying, a statute that says something like, go do good and nice things, agency. And then Congress gets the credit for saying, look, we told the agency to go do good and nice things. And when the agency goes and interprets that to do something bad, Congress can say that wasn't us. So I think you're exactly right that by exercising that muscle memory of making more decisions by Congress, some of the decisions might not be the best, but some of them will be good. And just by more routinely doing it, I think it would be better for self-governance.
Okay, thank you. Professor Dudley.
I guess I'd just like to say thank you so much for doing this and your other committee members who are involved. And if there are things that we can do to help you think about this, we'd love to. And I would definitely recommend the Bipartisan Policy Center report and also the National Academy's workshop report. But thank you again.
No, thank you. That has been added to the record in this. And you can be assured that I'm going to go back with my colleagues and say we need to be able to pull some of these ideas and figure out how we implement some of these things as well. Representative Schwartz.
And I, too, I just want to wish you good luck on this, and we're happy to, of course, be available to you and of course, the Bipartisan Policy Center. And I would just say, as a former member, my respect and admiration for the work that the Senate and the House does. And, recognizing how difficult it is sometimes to work all this out is no small matter. So there are efforts that you can do that I think are probably less scary than others in terms of changing procedure, but to make sure that as you just pointed out, that the record is clear as to what the intent was, and that it's Congress that makes the laws of the land. And then say that is really the job of Congress, and to do so in a way that we don't leave it to the courts to decide, and work with the agencies in a way that actually makes it as effective as possible and implement it to the degree that you lay out, to get the purpose and the intent and the mission the way you've formulated. So even in a time when I don't agree with some of the legislation, it's hard for me to say go forth and do it, but I do think that it is your responsibility, it is a congressional responsibility, and it could help with the public's understanding of what the law means and the impact on their lives, to have it in clearer language and be more directive. And I think that actually would be a great help to keeping our democracy strong.
Yeah, I do as well. Thank you again to all of you. Any additional ideas that you may have, we are all ears. And so appreciate all the reports and the work and the written statements and your testimony time today on it. Again, I apologize for having to take a quick break for votes right in the middle of it, but that is what they pay us to do, is to be able to go vote. So that's an area that we've definitely got to be able to take on. The record for this hearing will remain open for 15 days until Thursday, August the 14th, 2025, for submission of statements and questions for the record. Thank you again to all of you. This hearing is adjourned.